Let's talk a little bit about the significance of that testimony. No fingerprints, because so far we know there was a fire. We know there were innocent victims in that fire, 2 of which perished, another one who was injured and then passed away after the fire. We know that we can see on video a person spraying something and starting a fire. So my question becomes, if you can't use fingerprint technology, if you can't get fingerprints, how is the state going to prove that it's the defendant on that video?
Ashley, you and I have been covering this case for a while, and we've been asking ourselves, how is the state going to prove that Stanley Ford was the one who killed these 9 people, including 5 children? Well, we found out yesterday with the testimony about the alarm and the surveillance camera. Stanley Ford's alarm was disconnected just a few minutes before the fires happened. And there's video of someone leaving his house shortly before the fires and arriving. That's the evidence that the state is going to use to put him away and potentially put him on death row.
Yeah, let's talk about that death row. Let me ask you this, as a former federal prosecutor. 3 fires, 1 trial, 29 charges, death penalty. That's a lot against one defendant. Do you think that there's any potential appealable error in the fact that all 3 of these fires are being tried as one case?
You know, whenever you have these prior bad acts, what we call, it's always grounds for appeal. But generally, trial judges have a lot of autonomy and discretion. You know, this is the type of evidence that shows motive, intent, opportunity, all those things that you learn in law school and during the bar exam. And you're talking about 3 arsons, you know, 1 of which was failed. You have a attempted arson of a house, an arson of a vehicle. So this is all pretty consistent with the MO and the identity of the arsonist and the murderer in this case. So I don't think it's something that an appellate court would overturn or disturb on appeal to the extent that the state is able to successfully get a conviction against Ford.
And, you know, just a reminder, it's not that a judge doesn't hear about should these all be tried together, but rather there are pretrial motions filed for argument to be heard by the court, and the court then looks at the laws to determine, do these acts qualify as prior bad acts, and should it be heard as one trial or not? And so certainly the judge has heard the evidence in pretrial motions to make the decision that this is one that can be tried as one case. Let's talk now about the death penalty, because obviously that is the most serious kind of case in which they are seeking the death penalty. And there was a motion that was filed, and it was full of really great legal arguments, Neama, probably no surprise, by the defense to say there are many, many reasons why it shouldn't be a death penalty case, including the reasons that most attorneys are going to cite when they're arguing against the death penalty, and that is the cruel and unusual punishment, the 8th Amendment. So the judge heard all of these things and determined that it was appropriate to be treated as a death penalty case. In your experience and opinion, do you think that it's standard to file these types of motions to try the argument of, oh, it shouldn't be death penalty because?
No question, Ashley. You have to raise these 8th Amendment arguments. That's your job as a defense attorney. Even though they don't have much of a chance of success at the trial level, you need to preserve these issues for appeal. And that's what Ford's attorneys did. And ultimately, you know, there's public policy arguments on both sides. But if you believe in the death penalty, Ashley, this is a death penalty case. 5 innocent children were killed, as well as 4 adults, 9 total. And unfortunately for Mr. Ford, he hamstrung his attorneys. He didn't allow them to even negotiate a deal with the state that would have taken the death penalty off the table. That's why we're going to trial here. And that was something that the trial judge thought was so extraordinary that she wanted to determine whether Ford was even competent, because in his opinion, he was unwilling to negotiate anything pre-trial.
Oh, great points. Thank you, Neama. And there's some more history that hopefully if we get a chance to talk later, we'll go through. She actually said we don't have cross-examination, but I thank you for your testimony. What a great demeanor.
Yes, that was so polite.
And I think it's just a good way to, I don't know, I think it can be disarming to a jury to have a defense attorney that is not defensive, for lack of a better word.
Especially when you're dealing with law enforcement witnesses, sometimes they go after them pretty aggressively and they can turn off the jurors. So I agree completely.
and they have stepped outside in order to see that their next witness was in the hallway. I must also say, Neama, we can see the defendant there obviously on the screen. That's the first time I've noticed, it doesn't mean he hasn't done it before, that he was laughing and had more emotion on his face. He just said something to the person next to him, but that just gave me a little glimpse of a little more personality than I think we've seen.
I agree. He's been, that's the first emotion that I've seen. It's been well over a week that this case has been going. And even during the first trial, that mistrial. So, I mean, that was my concern with the case, that he would just come across as unlikable. That's why I would be very surprised if he were to testify. His attorneys would probably try to keep him off. I mean, but again, he seems somewhat difficult, so he may insist, in which case I think he'll get cross-examined pretty effectively by the state.
Right, and Joy and I, Joy Lim-Naquin with Court TV and I were just talking. She's live in Ohio, and we talked a little bit earlier about the fact that we don't know, obviously, yet if he's going to testify. But given the number of charges and 3 different fires, I feel like this defense is likely not going to give him super clear advice on testify or not until they really see all the evidence that the state puts forward.
Yeah, there's not a whole lot of direct evidence. We have obviously, what came in yesterday, the alarm evidence and the video evidence. I think that was the best so far. I mean, I agree. There's no question, Ashley, that this was an arson. I don't think anyone disputes that. The video evidence makes it clear. And that Ford did not like his neighbors and that he was an angry individual. So under the circumstances, I don't think that's something the defense can dispute. I think they're making the best argument that they can, which is that this was a drug house. And, I think taking the logical leap that this could have easily been a drug deal gone wrong, that's something that maybe some of the jurors can buy into. And I think they're going to stick with that strategy, talk about drug dealers, talk about prostitution, talk about other types of crime, and that way try to keep their client off the stand. I think if he were to take the stand, he's going to be cross-examined on the homosexuality comments, all the other statements by the neighbors, how difficult he was, how angry he was, and I think it's going to be challenging for him. I want to compare it to Bob Durst, who was a very effective witness, even though Lewin did catch him in many lies. I mean, he was someone who was able to essentially talk himself out of a murder, Morris Black down there in Galveston. I don't think Stanley Ford is that type of defendant, unfortunately. So again, I would be surprised, and I agree with you and Joy, if you were to take the stand in this particular case.
And as we all know, you can't change the personality of a person, so you can go through what they might be asked when they testify, but their personality is going to come through to the jury. The testimony and the evidence that's being presented, and there are really 2 different ways we know that trial attorneys can present evidence. You can either do it chronologically, or you could choose to order it as you're going to present it, perhaps by theme. In this case, the prosecution so far has been sticking to chronological. We know that they're dealing with the first fire that occurred in April of 2016 first. Do you think that's an effective way to present this evidence to the jury?
Actually, I do, but I do have to question the prosecution's strategy here. As a former prosecutor, I'd like to come out strong and finish strong. Especially in this day and age of social media, you may lose your jury in those first few minutes. So we had a very short opening statement here. It didn't really talk about much of the direct evidence that we saw yesterday and today tying Ford to these arsons. And we were frankly scratching our heads last week. Ultimately, that all came in, and sometimes prosecutors like to sandbag a little bit. But if I were the state here, I would have fronted that evidence instead of just really focusing on the motive and the type of person Ford was, because really that was the extent of the testimony that came out during the first few days.
The other thing that surprises me, Neama, in that testimony and seeing this video as many times as we have, that the person in the video to me is fairly callous. What do I mean by that? Okay, so they have a hoodie on or something that covers their head, but even so, you can plainly see that they're going up and spraying things and starting a fire. And I almost wonder, to me, it doesn't look like they're hiding. It doesn't look like they're trying to be stealth. Okay, maybe they didn't know that cameras were recording them from somebody else's porch. But even so, there's this little piece of me that thinks, was it just luck that the person in these videos was not identified by someone to say that is the person who did it.
Actually, it was surprising, and this is the video that we saw. This is what the prosecution played in its opening statement, and they admitted, which they had to, that we have no idea who this is. We know an arson was committed. We don't know if it's a man or a woman. We don't know if it's Ford. What I would have liked them to do is to focus on that timeline, the chronology that they admitted yesterday, those minutes, that the person leaving Ford's house turned off his alarm, walked, there was movement from his house. So either Stanley Ford's the unluckiest person in the world that happened to leave his house between 3 and 3:30 and return when these fires were committed, or he's the arsonist and the person who is responsible for the murder of 9 people. That's the key evidence in this case, the circumstantial evidence that ties Ford to these murders. Not the video of the arson. No one is disputing that an arson was committed and an individual walked with a hoodie and an accelerant, and after he failed a couple times, was able to successfully torch this house.
Yeah, I agree. Finch, you want to sure point out that the victims, at least one of the victims in the first fire, had alcohol use, drug use, and they can take away maybe some things to help their case, but they don't want to alienate the jury by blaming the victim.
It certainly is a fine line, but I think it's the best defense in this case, the drug use. It's the most plausible other theory that this was a drug deal gone bad. So I understand why the defense is going in this direction. Obviously, you don't want to alienate the jurors, especially when it comes to those 5 children. They're obviously completely innocent. All of the victims are. But if you go too far by attacking the victim, there could be significant blowback by the jurors. But I understand what the state is doing here. These cases are all about likability, whether it's John Lewin and Durst talking about his shoplifting and using food stamps, or the offensive comments that Ford is making in this particular case. If you're a prosecutor, you have to make sure that the jurors don't sympathize and like your defendant, especially in a murder case.
And I would suspect, although we haven't yet heard evidence about the second fire, that's the one you just referenced with 5 children, siblings, and their parents all perished. And I suspect we may not hear bad things about those victims because of the nature and that it's children. Up Morris Black in Galveston, we know that. He dismembered his body, and he admitted that on the stand during this trial. How do you think knowing that affects a jury thinking about the fact his wife is missing since the 80s, and he had the ability to actually cut up a body?
Well, actually, of the 3 murderers, Morris Black is certainly the most provable, and Durst, of course, walked away and was acquitted, at least of the most serious charges. And I would at least say Kathy's probably the next easy to prove. Susan Berman's a challenging case for the prosecution, but what they want to do is plant that seed in the jurors' minds that don't let this person get away with a 3rd murder. So that's why they're talking about all these other cases. This is someone who's certainly capable of killing. I'm addressing a point that Stanley, you talked about is, obviously we haven't heard the jury instructions yet. Those are coming, but I'm down the street and I'm here in Los Angeles and I know what they're going to be. The reason Valian is talking about things like common sense is, at least here in California, that's what the reasonable doubt jury instruction addresses. There's 2 theories of the case, one that makes sense and one that doesn't. The jurors are instructed to reject the theory that doesn't make sense. And other themes like lying, there's a jury instruction that this panel will hear that will say, if you believe that a witness is lying, you are free to reject all of his or her testimony. So Valian is setting this up for Lewin when he comes back in rebuttal, because we know Valian's a lot more soft-spoken. Lewin's been criticized for being aggressive at times. I think he's done a fantastic job. So they're playing off one another well, and we're going to hear a lot of discussion of these jury instructions during Lewin's rebuttal.
Thank you both for staying with me as we wait for this to resume. Let me ask you, if I could start with you, Neama, because you know I love picking your brain about California because you work there in California, very close to the courthouse where Durst is occurring. How typical or not is it that attorneys for closing argument do not have time limits imposed on how long they get to try to convince the jury of their side?
It's not typical, but Judge Wyndham has a very broad view of relevant evidence, and he's giving the attorneys a lot of leeway. both in terms of not sustaining many objections. And obviously, this is a case that he wants to see finished. I mean, we talked about Stanley Ford, a case that mistrialed when the pandemic happened and we had to resume. That didn't happen here. I think Judge Wyndham wants a verdict in this case. He's going to give the attorneys the time they need. He's allowing them to break up their opening argument, having someone else handle rebuttal. Again, something that you don't typically see cases here in Los Angeles or anywhere throughout California.
All right, Jim.